I have prepared a synopsis of the situation. I made 10 copies. Short summary.
You can share. We may not have enough. I don't know if there is. We don't need to share.
I have gone through the contract, and I don't know if Mr. Adams has, but I've gone through it very specifically. And at this point in time, it appears that Mead and Hunt has not given any type of a synopsis that I'm aware of, or my client, in terms of the problems with the airport construction project. In the contract are specific requirements that if there is not a bill paid, that they be told, that being my client, what the problem is. Simply to say, well, there's concrete in the ground is not sufficient. It has to be in writing from the architect and has to be identified. Now, one of the complaints, if you will, to my understanding, is the fact that my client did that without any type of knowledge. In other words, leaving the concrete in the ground. Well, if you look in terms of concealed or unknown conditions, the concrete or the foundation situation, to my understanding, was unknown at the time that the bid was let. Now, what's of significance is that you've now had Coleman, to my understanding, come and do a review of the situation there, and Coleman themselves, in a disclaimer, I don't know if you've read that, indicates that and I've quoted that from November 2010, says it must be understood that the results and conclusions drawn from the results have inherent limitations and uncertainty. In that particular situation, they go on to say, the limitations of uncertainty exist when site radar samples are collected and analyzed for the purpose of representing existing site conditions. Although special care is taken in the field to assure adequate sampling, the results of those radar samples are most representative of the exact location where the samples are collected. The results, however, are used as a basis for demonstrating existing conditions when in fact the overall actual conditions may be different. Now, in terms of the contract, Roots Law or any other bidders were required to look at the area to determine what the position is of Roots Law in the bid, and that's clearly outlined in the contract. It also, if I could refer to that section, there is 3.74, talks about concealed or unknown conditions. It says if the contractor encounters conditions at the site that are subsurface, which is the situation with concrete, or otherwise concealed physical conditions that differ materially from those indicated in the contract documents, or unknown physical conditions of an unusual nature that differ materially from ordinarily found to exist and generally recognized as inherent in construction activities of the character provided for in the contract documents, the contractor shall promptly notice to the owner and the architect before conditions are disturbed, and in no event later than 21 days after first observance of the conditions. We've attached emails dated November 21, from Robert Kapsner, March 11th, Robert Kapsner to Rootsla Concrete, Dwayne DeRay, and Tim Matthews, discussing the foundations in terms of the problems encountered. Then we've also enclosed a email back from, I'm sorry the copy is not complete, but again, March 29th, where the issue of the basement, tunnel, and foundation areas was discussed. Now, since that time, there was never anything in writing outlining what the problem was, what should be done, why the bill is not being paid. The other thing that we've attached is a building permit certificate of occupancy. And the airport board has indicated that the final inspection is approved. Mr. Sari approved it, and now non-payment is being claimed because of some sort of a deficiency. The bottom line here is that never has my client been informed in writing what the problem is, why it's a problem, and I think under the contract terms outlined in the contract and in this letter, my client is requesting either payment or what's the problem and why. I mean, why is there a substantial amount of money being held back when there's concrete in the ground that the contractor had told the architect about, and the architect never said anything. Further, the airport didn't say anything. I knew the concrete was in the ground. Now the project's done, the occupancy permit has been issued, and you don't want to pay. And that's what the bottom line is. And my client is a small business here in the Ironwood area and just can't afford not to be paid, and really can't afford to litigate this. And it should be paid, or it should be fixed. Mead and Hunt should be put on the spot. What's the problem and why? And why didn't you find this out and make a decision when the work was being done? And I think that's the bottom line here. My clients just can't afford to go on. It's impossible, and I'm sure Dave will indicate that too. At one time, I think the October meeting, there was a 4-3 vote that $3,000 would be withheld and the balance paid. That never showed up in the minutes, but it's my understanding that there was a vote to that effect. Now, what happened or how that occurred, I don't know, but the minutes never reflected that. I wasn't here, so I don't know. But apparently there was a 4-3 vote that was not reflected in the minutes. So we've outlined for you the contractual terms, why we think you should pay, and like they say, don't give excuses, give money. So, and really the bottom line is, who cares if there's concrete in the ground? I mean, I'm not a contractor, but how does that affect the operation of the terminal or the operation of the airport? The problem is with airline service, not with concrete. So that's my client's perspective. I don't know, Dave, you have anything else?